am Banu Dandona, Joint Director at ICSI. On behalf of the ICSI, I extend a very warm welcome to all the viewers at the third session of the Capacity Building Initiative of ICSI, the Companies Act, Enable, Evaluate and Excel. The topic for today is Incorporation of Company. The session would cover provisions related to incorporation of private company, public company, Section 8 company, alteration of MOA and AOA, payment of stamp duty, incorporation of company through SPICE form. To discuss this, we have with us Mr. Ashok Tyagi, Mr. Bhaskar Subramaniam and Ms. Jyotsna. Mr. Ashok Tyagi is a fellow member of the Institute of Company Secretaries of India and has over 40 years of rich experience with corporates. Currently, he is practicing as an expert of corporate laws, including retail law, real estate laws, arbitration matters, etc. He is an independent director on the boards of several companies. Mr. Bhaskar Subramaniam is with the Infosys Limited as industry principal. He has an experience of over 32 years. He is a fellow member of the institute and he has been instrumental in the implementation of the MCA, e-governance, e-forms under the new Companies Act 2013. And he was on the expert committee he was an expert committee member on the rules committee set up by the MCA. I would now hand over to Mr. Ashok Tyagi to take you through the session.
Good evening, friends. I am Ashok Tyagi, as already informed by ma'am. I just start the topic on incorporation of companies. Before that, I just wish to mention that economies in all the regions are implementing reforms, ease of doing business. The government of India has also taken various initiatives encouraging for setting up new businesses and to facilitate ease of doing business. Ever since notification of the Companies Act 2013, a significant increase has been witnessed in the incorporation of new companies. The Ministry of Corporate Affairs has simplified the process after a very long time by introduction of a new SPICE form, which is simplified forma for incorporating companies electronically on October 1, 2016. Now before we go for the details on incorporation, I just wanted to introduce regarding what kind of companies which we don't normally go for incorporation. Is a private company, including small companies, public companies which with having about 7 members and 3 directors minimum and other minimum things which are required. Section 8 companies are basically charitable companies or for the purpose of non-profit making business. Producer companies, as per the old Companies Act, some companies which are being incorporated by the agriculturist and other forums. Chapter 21 companies, part 1. They are the companies basically which are converted from LLP or society or partnership firm into a company. Foreign companies, this is basically not incorporation, but this is a registration which we are not discussing. This is just for the purpose of introduction. In private company, the new thing was added in the Companies Act 2013, which is one-person company. It is to benefit for a sort of proprietorship company where one person can do the business of his own, subject to certain restrictions which are provided under the Act. Maximum capital for one-person company can be 50 lakhs. Maximum turnover should not exceed 2 crores. Private companies, minimum number of members 2 and maximum 200 cannot exceed. Minimum 2 directors, restrict transferability of shares, prohibits public invitations. Producer company, as I have already discussed. Public company, minimum 3 members. Subsidiary of a public company is also to be deemed to be a public company, which is given in the Companies Act definition clause itself. Section 8 companies, incorporated for promotion of commerce, arts, science, sports, education, social welfare, religion and charity, etc. They are special companies basically for the business being carried out without profit. Chapter 21 companies, which I have already explained, is a partnership firm or limited liability partnership, cooperative society or society or any other business entity eligible to register as a incorporated as a company under the New Companies Act. The company further classified into, as we see in the forms, company limited by shares, company limited by guarantees, company limited by guarantee having share capital, company unlimited company having share capital, unlimited company not having share capital. Now we'll go for the incorporation modes for different type of companies. So we have SPICE form, as I have already discussed, for a private company, for public company, for Section 8 company, and of course for producer companies which are private companies. And form INC 7 is a chapter 21 company, producer company which is a limited company, company with more than 7 subscribers. So up to 7 subscribers we can use a SPICE form, but for others we have to use form INC 7. Now we'll go for what are the minimum requirements which should be there, without which the company cannot be incorporated. Application for DSC. DSC is mandatory for all the subscribers and the directors. The application of a proposed subscriber witness to the memorandum and articles of association should have valid DSC, otherwise it cannot be formed. Allotment of DIN, it is also mandatory as per the Act. So everybody who wanted to be a director has to have DIN. Up to 3 DIN can be applied in SPICE form. If there are more than 3 directors, then we have to take the process separately. But still, if something is there, we can check with our colleague from MCA. Reservation of name. One name can be applied. Now we are talking about SPICE form. Only one name can be applied. We cannot apply more than 2 names, more than 1 name at a time. However, if the applicant want to apply for more names, up to 6 names, they have to apply in form INC 1. Reservation of name. Reservation of name has its rules, guidelines, which have to be very clearly understood and read before a professional advise their promoters to incorporate a company. These are very detailed, but I am taking up 1 or 2 very important things which must be kept in mind. The name should not be identical with the name of existing company or limited liability partnership. The name should not be in contravention of the provisions of Emblems and Names Prevention of Improper Use Act 1950. The name should not contain the name of registered trademark or trademark subject to application. The name should not indicative of any separate type of business constitution like cooperative, LLP, trust, society, HUF firm, etc. The name should not include the words insurance, bank, stock exchange, commodity exchange, venture capital, asset management, nidhi, mutual fund, etc. Names requiring central government approval. Previous approval of the central government is required for the reservation of name if provided the name contains any word which gives the impression that the company is connected with the central or state government or local body authority or body constituted under the central government or the state government. The name must contain, the name contains like board, undertaking, federal, republic, Rashtrapati, president, prime minister, chief minister, minister, governor, municipal court, bureau, state scheme or Indian scheme, central or union, etc. These require prior approval from the central government or state government, whatever the case may be. Names similar to the existing business entity. If the name is identical, there are possibilities that the name are identical in the group of the existing business constitution like sole proprietorship, partnership or any other incorporated, unincorporated entity. The applicant shall provide the details of such entity along with no objection certificate from the owner of the business, partner or partnership, partners of the partnership. If the name is similar to an existing name, board resolution from that company should be provided along with the no objection certificate. The no objection should also be taken in the form of the resolution as well as a separate no objection. Now we find with the MCA, with the experience, there are certain errors which we do and the names are likely to be rejected. Name is very general. It includes the registered trademark. NOC has not been attached. These are very common which our friends in practice as well as in employment must ensure that these things should be taken care of so that minimum time approval would be obtained. Name is similar to the company or LLP. Name includes the word state, which we have already discussed. In principle of concern, regulator is not provided, is not enclosed. Names includes only the name of continent, country, state, city, etc. Names indicates a separate type of business constitution. Now we should discuss about the most important document which are required to be attached for the incorporation with the firm. Drafting of memorandum and articles of association, which are the charter and most important document for the lifetime of the company. While memorandum of association is a charter of any company, the articles contains regulations of the management of the company. With the ease of doing business, initiatives have been taken by the Ministry of Corporate Affairs. Every company except the following have to prepare MOA and AOA. Section 8 companies, INC 13. Companies with foreign subscriber not having DIN. Producer companies, Part 1, Chapter 21 companies. Companies with more than 7 subscribers. In case of each mentioned companies, physical copies of memorandum and articles of association have to be signed by the subscriber and attached to the SPICE form and form INC 7. Let me just take you through to schedule. MOA for different type of companies. Memorandum of association for a company limited by shares, table A of the new act. Company limited by guarantee and not having share capital, table B. Companies limited by guarantee and having a share capital, C, table C. Table D, unlimited companies and not having share capital. And last is table E, unlimited companies and having share capital. Now we talk about articles of association. Table F, companies limited by shares. Table G, company limited by guarantees and having a share capital. Company limited by guarantee and not having share capital is table H. Table I, unlimited company and having share capital. Table J, unlimited company not having share capital. I also suggest that all the professional colleagues, whether in practice or in employment, must also take these precautions while drafting M&O and AOA. Memorandum of association should be precise, but at the same time, with my experience, it has to be exhaustive, keeping into consideration the business period at least for next 10 to 15 years. These charters cannot be modified every now and then. So while drafting, this is the most important thing, that the memorandum should be precise but at the same time exhaustive for the enabling provisions which the company may take in next 10 to 20 years. Ancillary object should be descriptive to cover all aspects of the type of business the promoters intend to carry on. While drafting articles of association, either the prescribed table in Schedule 1 should be followed or table should be modified according to the business requirements. If we have like joint ventures, if we have other requirements of directors, inter-se shareholders agreement, etc., etc. These are very important, which should be done immediately or later on. Articles can also be modified from time to time. The entrenchment clause, if any, should be inserted separately to avoid practical issues on long run. Some entrench clauses have to be added, which should be separate than the regular this thing, because those entrench clauses basically meant for restricting certain powers of the company for a limited period, provided that the joint venture partner or lender or any other entity can make use of those articles. Latest amendment in the Companies Incorporation Rules 2014. Companies Incorporation Rules 2016, notification dated 22nd January 2016. Establishment of new CRC, Central Registration Center. The total deviation, it was from different registrar of companies. Now it has been centralized, name availability and incorporation of the company to a body called Central Registration Center for whole of the country. Removal of Rule 8(2)(b)(2) requiring consonance of name with the principal object. Earlier it was requirement that the name should be in consonance with the businesses which a company want to carry on, but that has been dispensed with. Companies Incorporation Third Amendment Rule. These are the notification which are very favorable for doing the business in a very easy manner. The name should be undesirable even if it contains trademarks subject to the application for registration. I have my different opinion, but we'll take up slowly with the government. Companies Incorporation Fourth Amendment Rules 2016, notification dated October 1, 2016. Introduction of SPICE form, which we have already discussed. Discontinuation of Form INC 2, incorporation of OPC. Form INC 7, incorporation other than Part 1 companies and companies with more than 7 subscribers. Now we discuss the incorporation process and understanding SPICE. SPICE is a very simple, easy, but before that we must understand what the detailed this thing by using the form, by reading the rules, by reading the kits which are provided by the MCA. Either you are certifying professional or you are a company secretary in employment. This is very important. This form will do lot of, is already doing lot of benefits to the professionals and to the stakeholders. SPICE form introduced by the ministry is an integral form used for incorporation of company. It not only facilitate incorporation, but it also allows registration of PAN, TAN, ESIC, Employee Provident Fund and Importer-Exporter Code. The SPICE form is divided into following parts: basic type, class of category of the company, main division of industrial activity, authorized share capital and members obligation, situation of registered office. We will deal it if during the questions of queries, if you have specific queries on these things, but as far as situation of registration office is concerned, this is optional. We can do it at the time of incorporation or within 30 days of the incorporation with a different form. Reservation of name, INC 1 is not to be filed if we want to make one application in this SPICE form, wherein we can apply only one name. Details of the first subscribers and directors. Details of the nominee in case of OPC only. Particulars of the payment of stamp duty. Mandatory registration for PAN and TAN. Because earlier when we used to incorporate company, after that it used to take 15 days, 1 month for all these things which have been already included for doing the ease of business. Now if you apply here, you have PAN number, TAN number, all registrations available, one window clearance. Mandatory registration of PAN and TAN. Registration of ESI, Employees Provident Fund and ESI. These are optional. These are not mandatory at the spice form initially. But if somebody want to opt out, they can do that. Now most important part is what documents to be attached. Documents is the most important part because this form is for the lifetime of the company. This form will be there and all these documents will be there. And if these documents are defective, many things you will have any problem. Now I just list of the documents which are required to be attached with this spice form by all type of companies, irrespective of any class. Affidavit and declaration by first subscribers, directors in the prescribed form INC 9. Affidavit for non-acceptance of deposits by the first subscribers and directors. Proof of registered office address or correspondence address in the same as the registered office address. So this is optional in case we wanted to opt from day one registered office, then it's different, and if we wanted to do it later, then we have to file a separate form. Copy of utility. What are the important things for the correspondence address? Copy of utility bills like telephone bill, gas bill, electricity bill, mobile bill, telephone bill, and other utility bills which should not be older than 2 months. Copy of the approval in case of proposed name contains any word which require central government approval or any approval from say SEBI or stock exchange or RBI and other bodies. Consent of the owner of the applicant of the trademark in case such company has a registered trademark. I mean the name is given with the registered trademark is there, then the applicant must obtain a NOC and consent of the owner of the trademark if it is based on the registered trademark or a trademark under registration. NOC from the sole proprietor, partners, associate, wherever they are applicable, please use that. NOC in case of the partnership or associate existing companies, they have to take the NOC for incorporating the new company. In principle approval like banks, stock exchanges, mutual funds, etc. I have already discussed about. Certificate of incorporation of foreign body corporate and resolution passed if the subscriber to proposed company is a foreign company and a company incorporated outside India. So a foreign company can also be a shareholder or a subscriber of the memorandum provided we will furnish all these documents. Resolution passed by the promoter company if the subscriber of the proposed company is company itself. If somebody want to incorporate subsidiary company, joint venture company using the same name, they can do it, provided they provide the required documents like certificate of incorporation. Resolution of promoter company if the subscriber is of the proposed is the company itself. No objection certificate by of the board resolution if name is similar to an existing company. If I am a promoter of 2, 3, 4 companies, I wanted to continue with the same name. So every time we have to give the no objection certificate. Affidavit in case of proposed name includes electoral trust. Interest of first directors in other entities in any case of the director has any interest in the proposed company. Proof of identity or residential address of the subscribers, directors, if any of the subscriber does not have then an application being made through this form. I think here the other documents includes PAN number, and now I think Aadhaar card will also become important, and we'll go through the forms which we'll discuss. NOC in case there is any change in the promoters from that mentioned in the INC 1. Sometimes it is decided that Mr. X and Y will promote the company, but in the meantime it is changed, then we need to obtain the objection certificate from the outgoing proposed director or subscriber. Form DIR 2 being the consent of an individual to act as a director, this is must. NOC from owner in case of the registered office is not owned by the proposed company. Incorporation compliances by different type of companies. Section 8 companies. I'll briefly take reservation of name. Drafting of memorandum of association as per INC 13 as prescribed in Rule 19 of the Companies Incorporation Rules and Articles of Association. Application in Form INC 12 for issue of license under Section 8 of the Companies Act to the Registrar of Companies concerned prior to the incorporation. Then we can proceed in the incorporation in the SPICE form. So we must have the license before we make the application for incorporation of Section 8 companies. Part 1 companies under Chapter 21 of the Act. Part 1 companies are capable of being registered under Chapter 21, Section 366 of the Companies Act 2013. The provisions of Chapter 2 relating to incorporation of company and matter incidental thereto shall be applicable mutis mutandis for such registration. There shall be 7 or more members for the purpose of registration of the company. Reservation in the name in Form INC 1, application in Form URC 1 along with INC 7, DIR 12, INC 22 for incorporation. I'll briefly touch producer companies documents also. Part 9A of the old Companies Act shall be applicable mutis mutandis to the producer companies, because in the current Companies Act producer companies have not been given in the manner in the Companies Act, and has not been repealed until the special act is enacted for the producer companies. Any one of the following combination of producer company can be incorporated. For the private company, if they want to introduce up to 5, minimum 5 or more. For public limited company, it is 10 or more producers, individuals, 2 or more producer institutions, combination of any 2. A producer company can be incorporated in Form INC 7, and I also discussed with you that the producer company up to 5 members being a private limited company can also be incorporated in SPICE form. Thank you very much. This is the legal provisions which are the requirement, and a person must see minimum requirement should be complied with. And on the SPICE form, I just wanted to say some important thing, because SPICE form itself is very important for the purpose of the company secretaries or the directors, because the representations which have been given, there are 14 representations which are required to be filled up before a director signs the application, which are enumerated in the form very clearly. I need not read for you. In case you have some questions, we can address that question. Similarly, the person who is certifying the form, they are very, very important, crucial, because this is a certification form. It is not attestation. It is not an opinion. So the company secretary in practice and practice specifically should ensure that whatever is written there, this has to be complied in letter and spirit. Those have to be evaluated, checked, verified very properly. And I would like to read for the benefit of my friends. Normally I found that people do not read very carefully. So that is why I just want to reiterate and repeat for the benefit of my professional colleagues. That says that I have been engaged for the purpose of certification in this form. It is hereby also certified that I have gone through the provisions of the Companies Act. So before we are undergoing for any incorporation, we have to read Act, rules made thereunder, SPICE form, INC, whatever is applicable, the rules and KIT. So we should be thorough that what we have to do. If we know that, we will not commit any mistake or will not be trapped under the provisions of law. So then I have verified the above particulars, including attachments from the original certified records maintained by the applicant, which is a subject matter of this form. Because this initial form is the most important form for the birth of the company. The draft memorandum and articles of association have been drawn up in conformity with the provisions of section 4 and 5 of the Act. The requirement of Act, rules made thereunder to the registration of the company under section 7 of the Act and the matter precedents. The other important things are that if we do the problem here, we declare that I further declare I have personally visited the proposed registered office given. This is very important. We should not do that if we have not visited, or I am certifying a form of a company which is located in Ahmedabad or Bombay. So you must visit at that place. I understood that it's liable for action under section 448 of the Companies Act for wrong certification if found. So we are giving this representation to the government. So my humble submission is all these forms and documents are very important for the incorporation of companies. So I will request my colleague to give certain queries or answers or problems being faced by them through professionals. They may be telling them. So I request Mr. Bhaskar to continue, please.
Thank you, Dr. Tyagi. Good evening, friends. I have with me my colleague Jasna from Emphasis. He is with me in the MCA project. So we have received many queries from the members and the users who are filing incorporation related forms, and we will take and discuss the main queries. Some are repetitive in nature, and of course we have also provided a comprehensive FAQs. For your convenience, I will read out some of the questions from the FAQ, and I will take the queries which we received from the members, and my colleague also will take some of the questions, and she will explain the table that is there in the FAQ in respect of filing of EMOA and physical memorandum and articles. So normally many questions are received, and generally we also get tickets with reference to the name applications. How many names can be applied for in SPICE? Please understand that this webinar is not only for experts but also for beginners thanks to the Institute's initiative. I would like to repeat the audiences, not only the experts, even the beginners. So we have taken the mixture of both. So we would like to take the questions, and we will avoid the repetitions. So the many queries and tickets are raised. How many names can be applied for in SPICE? It is only one name. However, INC 32 has a provision to use INC 1. That is, if you have already applied for a name through INC 1, that is, your INC 1 has 6 names, 6 proposed names. You can apply through INC 1. You can take the approved name through INC 1 and come to INC 32 and input the INC 1 SRN there and do the incorporation. So next repeated question is on INC 22. Whether INC 22 is still to be required to be filed with SPICE. It is not required to be filed with SPICE if a company is registered with the same address as the address for correspondence. In case the registered office address is different, INC 22 is required to be filed within 30 days of incorporation for intimating the registered office address. Next question normally we get as ticket is, what is the process for obtaining approved EMOA and AOA? Actually, you can obtain these because it is not the physical mode, it is electronic mode. You submit the memorandum and articles of association. You can use the certified copies facilities available on the MCA and obtain the EMOA and AOA copies. So, and many of the tickets is on the how to use electronic MOA, electronic AOA. Can physical copies of MOA, AOA be signed and attached with SPICE forms? Can an admixture of physical plus electronic MOA and AOA be used? So these type of questions, despite being self-explanatory FAQs available on the portal, we get from the users. Yes, it is mandatory to use electronic MOA and electronic AOA in case individual subscribers are Indian nationals, individual subscribers who are foreign national in case they possess valid DIN and DSC and also submit a proof of valid business visa, that during the period of incorporation they should have visited India and they should possess a valid business visa, and the non-individual subscribers based in India. Okay. And physical copies of MOA, AOA is required to be signed and attached in case non-individual subscribers are based outside India or individual foreign subscribers do not possess a valid business visa. In case physical copies of MOA, AOA is required to be submitted, then EMOA and AOA shall not be attached. Many of the rejections are because of this. So members are requested to be familiar with the FAQs, and my colleague Jasna will also take you through the table once I finish. So please listen to her carefully and also read the FAQs, which are self-explanatory, before you use electronic memorandum, electronic articles or physical PDF attachments of MOA or AOA. And another question which gets repeated is whether electronic MOA and electronic AOA is to be filed with INC 32 in respect of non-individual first subscribers who are based outside India. No, the answer is no. In respect of non-individual first subscribers who are based outside India, PDF attachments of apostillized MOA and AOA shall be attached with SPICE INC 32. Next repeated question is on proposed Section 8 company, whether it is required to file electronic MOA and AOA along with SPICE. No, you should not file electronic MOA and AOA with SPICE. Section 8 companies are mandatorily required to file MOA and AOA as PDF attachments to SPICE INC 32. So next repeated question is PAN and Aadhaar mandatory. Yes, you must be knowing that the company's incorporation rules notified has liberalized many of the requirements. Of course, Dr. Tyagi has briefly touched upon those. In respect of proof of identity and proof of residence in respect of subscribers and directors. So with reference to the amendment rules 27th July 2016, it has relaxed the mandatory attachment of proof of identity and residence in respect of subscriber having a valid DIN. Suppose if he has a valid DIN, so these proofs are not required. So next, as I said in my initial remarks, this question is very often repeated. The question is, can I attach MOA and AOA for few subscribers and EMOA, EAOA for rest of the subscribers? No. In case the proposed company is required to file MOA and AOA due to any of the whatever I have mentioned so far, you have to use physical MOA and AOA. Okay, in those cases you are not supposed to use electronic memorandum and electronic articles under any circumstances. Can SPICE be used for incorporation of producer companies? This question is very often received. Please understand, if the number of members of producer company is less than 7 and if it is a private producer private company, you can use SPICE. If it is a producer public company, please do not use SPICE, you use INC 7, because INC 7 only has the provision for more than 7 subscribers. I repeat, in case of producer public companies, please do not use SPICE form, use INC 7. Next question is, if a body corporate is one of the subscribers or promoters, can DSE of an authorized director be affixed? Yes, you can affix the DSE of the authorized director. And next, can foreign subscribers file INC 32 or are they required to file INC 7? Yes, foreign subscribers having valid DIN can file SPICE INC 32 with 33 and 34, that is EMOA, EOA as linked forms, provided they have a valid business visa and they visited India during the period of incorporation. However, in case of foreign individual subscriber without a valid DIN, you may use INC 32 with MOA and AOA as PDF attachments. So quite often we receive whether I can do some additions, modifications and deletions in article when I use the electronic AOA. Yes, you can do that. SPICE AOA has facility for adding, modification and deleting articles. And can we, because this specific question on the private company is being repeatedly faced by the stakeholders and they receive CRC resubmission remarks also. Please be aware that the question is, can we enter the conditions of private company as required under section 5 of the Companies Act 2013 in SPICE AOA INC 34? Yes, you can enter because INC 34 has the facility for adding, modifying and deleting the articles. And the second resubmission remark, normally quite often the people, the members and the stakeholders they get is, can we enter the names of first directors as required under the Companies Act 2013 in SPICE AOA? Yes, you have to enter the names of the first directors because it has a facility for adding, modifying and deleting the articles. Quite often we also get a basic question. Despite this question being having answered several times, if there are more than 7 subscribers to memorandum and articles, what shall I do? In that case, please use INC 7. This is regarding witnessing of documents if the subscriber to the memorandum is a foreign national residing outside India. his signatures and addresses, as you are aware, it shall be witnessed by a notary public, embassy, consulate officers of embassies as prescribed under the Rule 13 of the Companies Incorporation Rules. In those cases, how the DSC of such a witness be affixed? In such cases, SPICE INC 32 shall be filed with manually signed memorandum and articles. Okay. So, is DSC mandatory for subscriber? This question, of course, this question, the number of questions and number of tickets on this question has come down, but still I want to reiterate that it is necessary for acquiring DSC for every subscriber and the witness. Okay. And presently we have provision for the digital signature certificates of 7 subscribers plus 1 witness. So please be aware that these 7 subscribers and 1 witness have to have digital signature certificates before they embark on filing the SPICE forms with INC 33 and 34, MOA and AOA. Can we use SPICE form now for resubmitting incorporation applications filed in INC 2, INC 7 earlier? Of course, INC 2 is presently not available, but still this question is there because they have I don't know from where they have INC 2 in their custody. Please do not use that. SPICE cannot be used in such cases. Okay, and now only INC 7 is available for resubmission. Of course, INC 7 only for subscribers where more than 7, in case where the number is more than 7. Whether subscriber's photo is required in SPICE forms? No, subscriber photo is not required. And how many resubmissions are permitted for SPICE forms? Please remember that there are 2 chances for you to resubmit the SPICE form, and quite often we get whether OPCs be incorporated using SPICE forms. Yes, of course you can use SPICE form for incorporating OPCs. As you are aware, INC 2 is not available, and people also have a feeling that can I use SPICE form for LLP? Presently no, the SPICE form do not cater to LLP forms, and quite often we get tickets on the word limit for writing objects in electronic memorandum. For objects, main objects 3A, please remember the character limit is 20,000, and for furtherance of object, that is field 3B, it is 1 lakh characters. Accordingly you use the length of the form. Please clarify on attestation requirement in respect of foreign companies wanting to form a subsidiary in India. Attestation requirements are very clear in Rule 13 of the Companies Incorporation Rules. Please follow them. Of course, you people have already become familiar with uploading the SPICE forms. For the new beginners, the question is SPICE 33 and 34 to be uploaded separately? SPICE EMOA and AOA have to be uploaded as linked form to SPICE INC 32. And quite often this question is repeated: what if the subscribers to EMOA and AOA are different places as only 1 witness is provided? EMOA and AOA would be witnessed after all subscribers have signed, as is happening presently. And we also get tickets and queries on whether the SPICE form, let us say if they are rejected, whether the refund is applicable. Of course, refund is applicable. And what is the upload size of the maximum upload size of SPICE forms? It is 6 MB. And one more question that is repeated is the whether Nidhi companies can be incorporated with SPICE forms. Of course, you can do that. Nidhi companies can be incorporated using SPICE forms. And some of the other queries which we have got, I would like to attempt. And one member had said that how can I get command on Companies Act 2013 if I have studied only Companies Act 1956. Please study constantly the Companies Act 2013 also. You will soon get command over Companies Act 2013. And in respect of special characters not being accepted in INC 32, of course, the special permitting special characters in INC 32 is under consideration. These cases they get flagged to us because they have already one name approved with special character in INC 1, but INC 32 not accepting the special characters. Acceptance of special character in INC 32 is being considered. Once that is decided, the suitable notification would be there on the portal. Is it mandatory to obtain director identification number? I think I have already said. It is mandatory for those who are proposed to be appointed as directors or appointed as directors in the proposed company. Apostolization of document, of course, I have already touched upon. How to shorten the time for incorporating a company in India? This is a question that is quite often received. Please understand that with the government process re-engineering that has happened in Central Registration Center, the time limit for name availability, applications getting approved and incorporation forms getting approved has tremendously shortened. That is, within 1 hour in many cases names are getting approved, and in less than a day, if all the documents that is attached to the incorporation forms are proper, the companies have got incorporated. We have several feedback from several members, and they are very positives. And as a matter of statistics, I would like to tell you that the number of companies which got incorporated, in 2016 as against 2015 has increased almost by 15 to 20%, while in 2015 it was around 80,000. In 2016 it is around 95,000 companies have got incorporated thanks to the CRC and the reduction in the time taken by CRC for name approvals and incorporations. Okay, this is a piece of statistic, and the table and rest of the questions.
Mr. Bhaskar, we have received certain queries which I think we should answer jointly wherever it is required. I request you. The question number 1 is, what are the difference of incorporation made in Companies Act 2013 and 56? My friends, as I told you, the things have changed a lot. Forms have changed. Everything is changed. And because to do the business in a easy manner, as the Honorable Prime Minister has been insisting from day one. So as far as comparison, it is much better, as already Mr. Bhaskar has told you, and I also briefed that spice form and all these things which have come. I remember in the earlier days, incorporation used to take when incorporation used to take a week, 10 days, 15 days. Now everything is being done in 1 hour and 1 day, which is very good. Next, how many shareholders and directors are required in case of private company which is a subsidiary of a private company? I don't think even the old Companies Act also, the government was not permitting to incorporate as a private company provided the promoter will hold more than 50% shares. So private company in the existing this thing is not possible to incorporate, as I understand. But still, you want to say something on this? Same. How to apply to the central government for the name application with company name starting with central? It is not the question of name availability. You have to obtain the necessary approval from the state government or the central government or whatever body to permit the name central word to be used in the name, and that approval has to be received under the various internal requirements. But for the purpose of Companies Act, for incorporation, we need that approval which permit the applicant to use the word central. Is that correct? What is the minimum capital requirement for registration of a company? I think As of now, there is nothing, but on OPC, we have some reservation. Minimum capital requirement is not there. Earlier, it used to be there. For foreign exchange private limited company incorporation, I don't know what is this. Whether it is required to obtain prior permission of Reserve Bank of India, although Reserve Bank of RBI issues license after company incorporated. I have not understood the question, but I think you wanted to raise the question that where the shareholder and shareholders fund is coming outside India. All these things are derived by RBI under general rules or FDI, etc. And earlier FIPB was there, which has been abandoned under this act. So we just have to check what is there. So of course, no prior permission is required if it is under FDI. And for the other route, government approval route, maybe Reserve Bank of India or any other agency which will be required. Can we reimburse the preliminary expenses incurred by the promoter? Yes, we can do that in the old Companies Act also, in the current Companies Act also. Because somebody has to make expenses for incorporation of, and those expenses will be preliminary expenses. They can be refunded back to the person who will spend. What are the key points relating incorporation of a foreign subsidiary company in India? Key points are those foreign companies which wanted to incorporate as a Indian company, as a subsidiary company or a joint venture company. The process is exactly the same. There is no other process. There are no other approvals. Straight away, as Bhaskarji has explained, that we have to make the application in these forms. So I don't think there is any other change for foreign subsidiary incorporation. We are not talking registration of foreign company. We are talking subsidiaries or joint venture companies being incorporated in India by foreign entities. What are the common rejection points for spice form, which have been discussed by our friend Mr. Bhaskar in detail? We should not discuss further now. By getting no objection from the existing company, we can have the company with the same name. Will there not be a problematic to the other company? No, it is not permitted unless you have a NOC and board resolution from the existing company to incorporate it, not with the same name but a similar name. Same name, the company cannot be incorporated at all. It should not be similar name. Indian citizens and resident promoters wanted to incorporate company in India, but currently are promoters residing in US. In such cases, subscription page of Memorandum and Articles of Association, who will witness? I think you have already answered.
Rule 13,
you want to say something?
Rule 13 is clear. Rule 13 of the Companies Incorporation rules already contains those.
In spice form 33, 34 or physically M&A, same you have already replied. How and when to file the refund form if the spice form gets rejected?
You have to incorporate the next.
We can adjust in the next, are you saying?
Next,
No, you will have to file the new form for incorporation of a new company.
Then you
so
can
once the new company is incorporated,
Then-
you can give a reference of the SRN of the form which got rejected, and you can claim a refund for the old form.
I think it is clear. If we apply for this, again file the form, and if the new company is incorporated, then we can apply for the refund of the money which we have paid.
Without filing the succeeding form for incorporation, you cannot seek refund for the previous form which got rejected.
But I have my own doubt. This is only for the registration amount, but not for the stamp duty, I doubt. Stamp duty will not be refundable. Only the money which is with the MCA.
Stamp duty also gets refunded.
Good. Whether we require to file DIR 12 after the approval of spice form?
No. No,
Not required.
not required.
Is form INC 3 a physical form which is to be attached with the spice form in the incorporation of OPC?
It is
Yes,
OPC
yes.
nominee, yes.
Yes. So the attachments, the relevant attachments become mandatory depending upon what type of company you are going to incorporate.
Is INC3 physical form which is to be attached in such a thing? What is the procedure for refund of stamp duty? We have already discussed in rejection. This will be refunded. This is the state government subject. If the proposed director does not have DIN, how can he get the DIN in MCA portal in order to register his DSC for digitally signing DIR 3?
Associate DSC. Associate DSC.
Means professional?
No, not only professional. The person who wants to get direct identification number, he has to associate his DSC.
Sorry,
Can you explain?
can we get the question?
Can you explain?
This question.
If proposed director does not have DIN, how can he get registered in MCA portal in order to register his DSC for digitally signing?
Yeah, he has to associate.
No, okay. So for applying in the form DIR 3, you need to be, the DSC need not be attached or associated with the DIN, because you're applying for the DIN, right? So the DSC that is required to be attached in the form is that of an applicant. It does not say director. So there the form does not check the association with the DIN, with any DIN.
Thank you. I think it is very clear. It is registration is required only after the DIN is allotted and you want it to be a director in another company, then only registration is required.
Association.
Association is required.
Association.
Okay, that's good. If the proposed, can DDA slip enough for a documentary proof for the situation of registered office? I think these are practical questions. DDA slip is nothing. I don't know what document you are referring. DDA slip is not a document. You have to attach the document which should be to the satisfaction of the approving authority. Basically either a lease agreement or some sale deed which is required to be attached. And other than this, if the sale deed is say some 20 years old, then you have to attach another proof like municipal corporation or local bodies bills, etc., so that it will prove that you are still residing there.
Correct.
So old these things will not do. In case of foreign body corporate as subscriber to MOA, the country does not have COI as constitutional document. In that case, what documents ROC can insist? In case of foreign companies, we are saying in the form that in case COI is not there, we can make the attachment. SIN-DIN is not there.
In the question, wherever there is a body corporate, which is a non-individual, yes. So non-individual foreign body corporate, wherever he is a subscriber, there is no question of linked filing of EMOA or EOA, and he has to submit apostillized MOA and apostillized AOA. Yes.
The question is what documents can insist as a proof of certificate of incorporation
Of the foreign body corporate.
Whatever the registration document of the foreign country can be attached as the proof.
That was even in the old Companies Act. We have been doing like this.
There is no change in that.
What process we need to follow for NRI non-resident person in process of registration and DIN?
In process of registration. Okay, we can take it up with the table once we go through the FAQs. We will touch upon the FAQs specifically for the manner of application of MOA and AOA. So we'll touch upon that.
In case the subscribers are illiterate, they even can't sign documents. What they could be do with thumb impression, then how we proceed for the incorporation of a private company, how they write on subscribers page.
They can use DSC, digital
DSC. DSC can be used, it's very clear. They have
as a private company, they can use the digital signature certificate and use SPICE form for incorporating private companies.
Their subscribers
but I understand that we should give as a prudent this thing. If somebody is uneducated, illiterate, whatever he is signing, he has to attach a declaration that he has understood what he is doing and what is this memorandum and articles of association.
It is actually there in the rule 13 as well.
So anyway, it is in the
specifically
rule,
for
but in general parlance, common sense, it is required that these things should be there.
She will take the table.
Yes, please.
What just now you please explain the different situations wherein the electronic memorandum and physical memorandum are supposed to be filed by the users, because it is quite often many queries and rejections do happen in CRC. So we have prepared a table. My colleague just now will explain, and over to you just now.
Yeah, good evening friends. We are going to touch upon the topic which is most commonly asked with respect to the filing of Memorandum of Association and Article of Association, the manner of filing these documents along with the SPICE form. It is very clearly explained in the FAQs that are available at the MCA portal, and I will also try to give a brief out from that table itself. Now if we look at the SPICE form has a field number 6 which talks about the first subscribers and the directors of the company. Within that field we have 4 types of differentiation between the subscribers. One is the non-individual first subscriber. That means wherever there is a body corporate, be it a company, LLP, firm, whatever. So wherever there is a question of non-individual body corporate, there is a field 6B that comes into picture. Then there is a field 6C which talks about individual subscribers who are not directors. So these the people who or the subscribers who will be mentioned therein, those are only purely individual subscribers, they are not directors. Then we have a field 6D which talks about individuals cum directors. That means they are subscribers as well as directors of the company. And we have a field 6E which talks only about the directors. So the people who are going to be mentioned in field 6E, they will only be directors, they are not the subscribers to the company. So that is the basic distinction within the field 6. Now the question with respect to the manner of application of Memorandum of Association and Article of Association to the SPICE form, the attachments or the applicability of the attachments, it is coming through the Rule 13 of the Company's Incorporation Rules 2014. So in order to understand it correctly, I think we should go into detail with respect to the Rule 13 of the Company's Incorporation rules. However, based on those rules, we have identified the situations whereby the applicant is required to either manually attach, that is postalized MOA, AOA as attachments, or through linked filing of MOA and AOA. I'll just give you the situations where these are applicable. Now wherever there is a question of non-individual first subscribers which are based outside India, it does not matter who is the authorized representative in such cases. It may be that the authorized representative is based out of India or based within India. But whenever, as soon as a foreign non-individual subscriber comes into picture, the question of attaching EMOA and EAOA is not applicable. That means wherever we have a foreign body corporate as a first subscriber, the applicant has to manually attach the Memorandum of Association and Article of Association, which is apostalized. Why we need apostalized? Because it comes through the rules. So wherever it is based outside India, it will be apostalized MOA, AOA as attachments. Wherever we have non-individual first subscribers who are based in India, in all such cases, it will be mandatory to attach EMOA and EAOA. Then wherever we have Indian nationals as Indian nationals and specifying, because it will cover the persons of Indian origin as well. So wherever we have Indian nationals being the subscribers cum directors or subscribers other than directors or the directors, wherever we have Indian nationals in question, it has to be mandatorily MOA and AOA as linked forms filing. Then we come to the next question of foreign nationals. Now foreign nationals can be subscriber cum directors, subscribers other than directors as well. In both these situations, in case, as per rule 13, in case the person, the applicant is claiming that the person has travelled to India for incorporation of a company, then in such situations he is supposed to attach or submit the proof of a valid business visa that he has travelled to the country for incorporation. That would suffice, and it would mean that he has travelled to India, he has been in India for incorporation, and in such cases he can attach MOA and AOA. However, in case he does not have, the applicant does not submit a valid business visa, then the understanding would be that he has not travelled to India for incorporation, and in all such cases it will be mandatory to attach the apostolized memorandum of association and apostolized article of association, irrespective of what other subscribers are. Okay, and now we come to the foreign nationals who are not having valid DIN. Now in cases where we are saying that the foreign national is not having a valid DIN and he is a proposed director, in all such cases it is mandatory to attach apostolized MOA and apostolized AOA. So I hope that the question with respect to the manner of filing MOA and AOA is clear. Now going forward to the other questions that are frequently asked, we will take it up one by one. Is it mandatory to apply PAN and TAN along with the SPICE form? With the recent change to the SPICE form, yes, it has now become mandatory to apply PAN and TAN for all the companies who are incorporated by way of SPICE forms. What is the fees payable for PAN and TAN? So the fees which is charged is for PAN 107 rupees and for TAN 63 rupees becomes payable, and it is clearly mentioned in the challan that gets generated. Whether fee towards PAN and TAN is payable separately? No. Why? Because while submitting your SPICE form, whatever challan gets generated, it has the description specifically. So there is no need to separately file any fees for PAN and TAN. It says a consolidation challan gets generated at the time of filing SPICE form, and that challan contains the details of the form fees, MOA, AOA, PAN and TAN. What is the next step after filing SPICE forms and making payment? The user is required to visit the MCA portal and access the service, submit application for PAN and TAN. He is supposed to download the form 49A and B and affix his DSC, and then upload the same forms again on the portal, and this completes the process of filing the SPICE form, and based on the filing of the SPICE form, he is supposed to receive the PAN and TAN as well as the incorporation of the company. Please provide the contact details of officer responsible if PAN card is not received by the user. Please note that once the certificate of incorporation is received, it shall indicate the PAN of the company as well. In case of non-receipt of PAN cards, stakeholders will have to check the status with the tin.nsdl.com website. What are the various steps to be followed while uploading PAN TAN applications? Now we have a separate document which explains the entire process. So you can go through that document for a clear understanding of the entire process step by step. What are the file naming conventions for 49A and 49B? The only thing to be considered is that we should not have any special character within the file name of 49A and B. In cases spaces are there, even the spaces are not allowed. So those are the conventions, file naming conventions. Is resubmission of Form 49A and 49B also required in case Form SPICE is marked in resubmission? Yes. In case the SPICE form is marked under resubmission, the entire process of submission of the form is not complete until and unless the Forms 49A and 49B are also uploaded. So yes, 49A and 49B will have to be uploaded for proper resubmission of the SPICE form. Form 49A and B is generated blank. What should be the next step? This was a very common query when we had revised the SPICE form, but we are not getting these queries now. So instead of opening the documents directly, please save the form first on your personal desktop or your laptop, and then you should affix your DSC and open the and it is only after you save the form in your system that you should open and view the form. If you try to open it directly in your web browser, there may be some cases where you are not able to see the form. So that is why we propose that you should always first save the form and then open it. Are AO codes for PAN and TAN different? Where can one find these AO codes? AO codes for PAN and TAN are different, and we have the separate links. nsdl.com, it contains the separate links for AO and AO codes for PAN and TAN separately, and we also have a link in our MCA portal FAQs also. You can go through that link and open the page, and you can go through the AO codes. What is the mode of grievance redressal in case of technical problems, that is form upload, pre-scrutiny, DSC, payment related queries? You must raise a ticket on the mca.gov.in my services and await for a resolution. However, in case of CRCs, you can also queries, you can also drop in a mail to crc.escalations@mca.gov.in, and also we have our MCA help desk where you can call at the help desk line and get your queries resolved. So thank you.
Now we request Madam to
Thank
take
you
it up.
to our esteemed members present here. I would like to express our sincere thanks to Mr. Ashok Tyagi, Sri Bhaskar Subramaniam ji and Jasna for sparing their valuable time and knowledge with us. I'm sure their expertise and their thoughts will be very useful for you in your professional journey. With this, I would like to present a small memento to Sri Ashok Tyagi ji.
Thank you, ma'am.
And also to the team from MCA Infosys, Sri Bhaskar and Jasna madam. Thank you, viewers. Thank you.